Good afternoon, everyone. Before we begin today's event, I'd like to provide you all with a few announcements. To share your thoughts today about today's event and stay connected with us for future programming, please tag and follow us on Twitter. For information about past year's competitions, please visit the link provided in the chat. And lastly, I'd like to remind you all that today's event is being recorded. And with that all out of the way, let's begin. So it is my great honor to welcome you all to the 34th annual Jeffrey G. Miller National Environmental Law Moot Court Competition. My name is Achinti Vithanage, and I am the Associate Director of Environmental Law Programs and an adjunct law professor at the Elisabeth Haub School of Law at Pace University. The Jeffrey G. Miller National Environmental Law Moot Court Competition, fondly known by the acronym NELMAC, is an annual flagship event of the environmental law program here at Pace Law. Every year, law student advocates nationwide assemble at Haub Law to compete in the largest inter-school moot court competition under one roof. This is the second year that we are hosting the competition virtually. And while this reality transformed the way in which the competition was traditionally delivered, the remote setting also made way for notable benefits. For instance, students participated from around the country, from Hawaii to Florida, and so did judges, with some even joining us internationally. We also significantly reduced our carbon footprint, which in itself is something to celebrate. I am pleased to say that 51 law schools competed and over 300 students, coaches, and judges participated this year. Now, usually we do our note of thanks at the very end, but today I would like to begin with it to honor the tremendous work of the many volunteers who made this event a success. I want to first acknowledge Professor Carl Copeland, who wrote this year's NELMAC problem. And what a stellar problem question at that, for both students and us judges. At its simplest, this year's problem revolves around the reduction of pollutants in a water body and conflicting views on the best way to do so. Indeed, this competition is distinctive in that three adverse teams argue the issues, reflecting the fact that environmental litigation frequently involves multiple parties. And in this case, a nonprofit group, the state, and a government agency. Of course, this is too simple a description, and you will soon see that Professor Copeland's problem is much more nuanced, technically challenging, and is riddled with enough legal perplexities to give all parties involved some great arguments to put forward. A note of recognition also goes to our environmental law fellow, Katie Horner, who edited the NELMAC problem and wrote the bench memo, and who also happens to be hosting this final event behind the virtual screen. I must also commend the work of our NELMAC chair, Kristen McConey, who led the competition with such poise and strength, and her merry band of student vice chairs, Alexandra Tamburino, Megan Gaddy, Daniel Guarancino, Mackenzie Moonen, Andre Arias, Julieta Duran-Buxbaum, Carolyn Brumrill, Amalia Talty, Zach Roy, Gabriella Michael, Tatiana Kalimpom-Burke, and Madison Biakowski, not to mention all the student bailiffs and volunteers who were involved. Also, NELMAC's success is in 1,000 ways owed to our program manager, Lorraine Rubik, who worked tirelessly along with the environmental program coordinator, Ann Olson, to make this year's event the best it can be. Thank you to all the attorneys that took the time out of their busy schedules to judge the earlier rounds. And of course, thank you to our final round judges today. We truly appreciate you doing this, and it allows for an amazing experience for our students and the competitors. To all the competitors who worked incredibly hard for this months-long competition, and despite all the stress, you will look back on this experience fondly, and I hope that one day you will return to our halls, virtual or otherwise, to judge a future NELMAC competition. And with a final word of good luck to the finalists, I'll turn it over to my environmental law colleague, Professor Carl Copeland, the director of the Pace Environmental Litigation Clinic and Professor of Law Emeritus at the Law School. Professor Copeland, the virtual podium is yours.
Okay, thank you. And thank you for your very kind welcome. And thank you so much to our judges, final round judges who are here and giving their time to help the judges competition today. And also congratulations to the teams that made the final round. You've worked really hard, and the arguments I heard yesterday in the semifinals demonstrated just how thoroughly prepared the group has been this year. And as Cynthia pointed out, I am fully responsible for this problem with all of its complexities, intricacies, whatever errors are in the problem. I like to think of them as just little wrinkles for the students to discover. And also for the challenge of the problem, which I like to think of posing the challenge of whether law and a regulatory system is up to the challenge of solving a discrete environmental problem with many, many working parts. I've really enjoyed hearing the arguments so far. And as I say, I always learn something, even though I've been teaching in Clean Water Act for 25 years now. This is a Clean Water Act problem. I always learn something about the problem I wrote from the students who prepare it and argue it. Again, thanks so much for the judges who are taking time out of their busy schedules to learn another case and be prepared. I would like to introduce them individually. So presiding today will be Alexandra Dapolito Dunn, a partner in the Environmental Safety and Incident Response Group at the international law firm of Baker Botts, with 25 plus years of experience of practice at the local, state, and federal levels of government. Ms. Dapolito Dunn brings to clients extensive institutional knowledge and a keen ability to help solve regulatory problems. Her deep relationships across the nation and reputation for transparency, fairness, and equity make her an effective presence in difficult settings. Ms. Dapolito Dunn largely works with major companies and national organizations on the regulation and management of emerging contaminants, particularly integrated per and polyfluoroalkyl substances, PFAS and FAS, on environmental justice and risk communication, chemical regulation, enforcement, and compliance assistance and risk communication. From 2019 to 2021, Ms. Dapolito Dunn served as an assistant administrator for the U.S. Environmental Protection Agency's Office of Chemical Safety and Pollution Prevention, and it's worth noting that she was confirmed to that position by a unanimous Senate, even in these very partisan times. She oversaw 900 career staff, was responsible for the creation of national policies, implementing federal laws governing chemicals, pesticides, and pollution prevention. Prior to that, Ms. Dapolito Dunn was EPA administrator for the New England region, Region 1, from 2018 to 2019, where she focused on watersheds, enforcement, and environmental justice. Ms. Dapolito Dunn also served as executive director and general counsel of the Environmental Council of the States, the National Nonpartisan Association of U.S. State and Territorial Environmental Commissioners. She's held other dynamic positions in her career, including executive director and general counsel of the Association of Clean Water Agencies, and something we're very happy about, the Dean of Environmental Law Programs at the Elisabeth Haub School of Law at Pace University, General Counsel of National Association of Clean Water Agencies, and counsel at the American Chemistry Council. Ms. Dapolito Dunn is nationally known author on topics of green cities, urban sustainability, environmental justice, and watershed management. And she has also taught environmental justice at 3 law schools. Ms. Dapolito Dunn serves on the Leadership Council of the Environmental Law Institute, the Board of Regents of the American College of Environmental Lawyers, and as leader of the American Bar Association's section on environment, energy, and resources, and on the section's litigation, environmental litigation committee. So welcome back to PACE, and thank you so much for your time today. Thanks again for being here. We also have helping to judge today the Honorable Mary K. Lynch, an environmental appeals judge on the United States EPA's Environmental Appeals Board. Judge Lynch has extensive litigation and management experience in both the private and the public sector. She has served in several leadership positions within the EPA, including as Associate General Counsel for the Waste and Emergency Response Law Office, leading the agency's participation in U.S. Supreme Court, federal appellate court, and federal rulemaking practice in these subject areas. Prior to that, she served as regional counsel for U.S. EPA Region 4 in Atlanta, Georgia. There, she led a large interdisciplinary staff, including attorneys and engineers, to provide legal counsel for civil and criminal environmental enforcement cases, defensive litigation, counseling issues, and general law matters. Judge Lynch has served as the vice chair of the Deepwater Horizon Natural Resource Damage Trustee Council, where she advised on the complex and unprecedented issues arising from that matter. Prior to joining EPA, Judge Lynch was engaged in private practice. Judge Lynch's work has been recognized with numerous awards, including the Meritorious Presidential Rank Award, the EPA Excellence in Management Award, and EPA in Gold and Silver Awards. Judge Lynch earned a Juris Doctor degree from the University of Georgia School of Law, where she served as executive editor of the Georgia Journal of International Comparative Law. She earned a Bachelor of Arts magna cum laude from Boston College, where she majored in history and was part of the Scholars of the College program. So thank you again. Thank you very much for being here, Judge Lynch. And finally, we have Professor James May as our third judge today. And I also like to think of Jim May as a member of the PACE family, because even though it's not on the bio here, He has one of the very first LLM degrees that was issued by Pace Law School. I won't say how far back that dates him, but it's nice to have Jim back here in the Pace family to judge today's event. James May is a visiting professor, actually back here physically this semester too. He's a visiting professor of law here at the Elisabeth Haub School of Law at Pace University this year, and was also a visiting professor at the S.J. Quinney College of Law at the University of Utah in 2021, and serves as a distinguished professor of law, founder of the Global Environmental Rights Institute, and co-founder of the Dignity Rights Project at the Widener University, Delaware Law School. Most recently, Mr. May is the immediate past president and co-founder of Dignity Rights International and a board member of the Normandy Chair for Peace, the Earth Law Center, and the Green Watch Institute. He serves as a special representative on harmony with nature for the International Council of Environmental Law and chaired the American Bar Association section on Environment, Energy, and Resources Task Force on Environmental Justice, which culminated in the enactment of a resolution on environmental justice and the establishment of a new ABA Presidential Task Force on Environmental Justice. He is an inductee of the American College of Environmental Lawyers. He's the co-chair of the 22 annual meeting. He's Phi Kappa Phi board and the Delaware Valley Environmental Inn of Court and the National Judicial College. Professor May has authored, co-authored, edited, or co-edited 21 books, has published 52 book chapters, and his works have been widely adopted and translated. Professor May has also published 67 law review articles, including at the journals at Yale, UCLA, Cardozo, Kansas, Denver, Pace, and Vermont Law Review, and 75 other legal works, including the United Nations, American Bar Association, Environmental Law Institute, and Bloomberg Press. He has received numerous awards and recognitions, including from the American Bar Association, the Sierra Club, American Canoe Association, Pace University, Haub School of Law, and Widener University. Law Dragon has recognized him as one of the world's most influential environmental lawyers. So again, thanks so much to all three of our judges for taking time to be here today. I hope you've enjoyed learning about the problem, and I hope you enjoy learning a little bit more about it when we hear from the competitors in just a few moments. And with that, I would like to now introduce Kristen McConey, the second-year law student at the Elisabeth Haub School of Law and this year's chair of the NELMEC board. Kristen?
Thank you, Professor Copeland. Good afternoon, everyone. I would like to begin with a brief introduction of the final round's teams and some logistics. Team 46 will be representing Chesapeake Plain Lake Watch and will be the first team to present its arguments, followed by Team 29 representing State of New Union and Team 8 representing the EPA. After all of the teams have presented their arguments to the judges, each team will then have a brief time for rebuttal, after which the judges will turn off their videos and mute their mics in order to deliberate and determine which team will be this year's winner. Thank you to our judges and this year's final round teams. I look forward to hearing your arguments. With that, I will turn it over to Dana McClure, who will present the bailiff's cry.
All rise. Oyez, oyez. The United States Court of Appeals for the 12th Circuit is now in session. All those having business before the court, draw near and give attention. God save the United States and this honorable court. Be seated, please come to order. First on this docket is the case of Chesapeake Plain Lake Watch, State of New Union, and U.S. Environmental Protection Agency.
May I proceed?
Yes, you may, counsel.
May it please the court. My name is Mikaela Johnson, and along with my co-counsel, Maia Foster, we represent the plaintiff, appellant, cross-appellee, Chesapeake Plain Lake Watch, or CLW. At this time, we'd like to reserve 2 minutes for rebuttal.
That will be fine.
Your honors, this is a case about protecting a body of water in our local community. It's about a once pristine water source that's been defiled by sewage and sludge. It's about a body of water that ought to be protected and returned to its natural state. We ask that you find for CLW on the following 4 issues. First, that this case is ripe for review. Second, that a TMDL that allows for BMPs without reasonable assurances is arbitrary and capricious. Third, that a phased-in approach in a TMDL is impermissible under the Clean Water Act. And fourth, that the word total in a TMDL allows for waste load and load allocations. I'll be handling the issues of ripeness, and my co-counsel, I'll be handling the issues of ripeness and BMPs, and my co-counsel, Ms. Foster, she'll be handling the other two issues today. As a threshold matter, Your Honors, this case is ripe for review. Now, the Supreme Court held in Abbott Laboratories that there are two factors that a court considers when determining whether a case, pre-enforcement, is ripe for the courts to hear. First, the issues must be fit for adjudication.
Excuse me. We're familiar with the factors for ripeness, so I'm wondering if we can just get kind of right to it and how they apply. I mean, we're also, as judges, we have limited authority. Our authority is given to us by the Constitution under Article 3, and then further limited by Congress. So we can't just do anything we want, even if we want to do it. And we have agencies too that are established by Congress with members who are appointed by the president. So there's a democratic function to these agencies as well. And part of the bargain in our system is to give the executive branch the opportunity to get things right to begin with. So with TMDLs, as I understand it, they're a number. Now, the number doesn't have an effect until it finds its way into a permit for point sources or a best management practice for a non-point source. So help us understand how you think that that's fit for review at this point.
Yes, Your Honor, this court's power is bound under Article 3, and this case falls within Article 3 because they are fit for judicial review, that first factor. Now, TMDLs do have an impact even before they're issued into that number and that permit, like you said. That's because there are hardships that happen to the party, but also the case here today is a legal issue.
Counsel,
So
can you expand more on the harm and perhaps address the Ohio forestry case?
Yes, Your Honor. Ohio Forestry held that if there's substantial practical harm that could come as a result of the issuance of a TMDL, then there are hardships and it makes it right for the court to hear. Now, here, both Chesapeake Lake Watch and New Union face substantial hardship if review is delayed. Now, that's because New Union faces substantial implementation costs as a result of this TMDL. Now, Chesapeake Lake Watch itself has substantial hardship because our lake is dying. This record spans over 3 decades, and we've seen this lake consistently deteriorate.
Counsel,
yes,
this is Judge Lynch. I want to ask you about language in Abbott that says that the challenged action, so that's the TMDL, which I think we all recognize is just an informational tool, it has to be felt in a concrete way by the challenged parties. So I'm not understanding how simply adopting an informational tool satisfies this requirement in Abbott.
Yes, Your Honor, the concrete impact in this case is both the implementation costs that New Union faces and also the fact that this TMDL locks in the status quo. Our lake is dying. With each day that passes without this court taking this case and deciding the legal issues, our fish keep dying, the property values keep declining, tourism keeps declining. Those are the concrete impacts that Abbott Laboratories asked for and are present in this case. Now,
Counsel, I feel that you're making some very good, important policy arguments about why you and your members want immediate redress. But going back to my colleague, Judge May's comments, what authority does this court have to address the concerns that you're raising?
Your Honor, this court has the authority under both Abbott Laboratories, which addresses prudential concerns of ripeness, and it also has the constitutional authority under Article 3. Ripeness is part of the case or controversy requirement that courts must consider when determining whether or not they're obligated to take on a case to hear. Now, because of the authority that this court has to decide ripe matters, and because this case falls or meets both those two Abbott Laboratory factors, They're both fit for judicial review because these are legal issues that the court is deciding, and it would not benefit from further factual development. And because both Chesapeake Lake Watch and New Union face substantial concrete hardship if review is delayed, that's where the authority comes from.
Counselor, let me follow up on that about the fitness again. On the fitness side of it, again, the way I understand it is, here the waste load allocation component of the TMDL would have to be incorporated into a Clean Water Act permit. Isn't that right?
Yes, Your Honor. Waste load allocations would have to be incorporated into NPDES permits.
And there are 2 NPDES permits. They've expired, but there are 2 NPDES permits at issue here, one for the slaughterhouse and one for the sewage treatment plant. Isn't that right?
Yes, Your Honor. Now, those NPDES permits have actually been filed for renewal and they're pending current approval. But the fact that those NPDES permits haven't yet been issued is exactly the harm that Chesapeake Lake Watch is alleging. There's not a single NPDES permit right now issued that controls for phosphorus discharges. So
right. What I'm getting at is that it's just about the ripeness part, about thinking about fitness for review. Couldn't your organization challenge the permit that's issued that incorporates the waste load allocation for the slaughterhouse or for the sewage treatment plant when that time comes?
Or the delay in issuance of the permit, understanding that they are delayed, you could bring an action against the state permitting authority for delaying permit issuance.
Your Honor, we could, but those NPDES permits are being delayed because of this TMDL, because New Union is also arguing that this TMDL is insufficient as a matter of law. They're not arguing.
Counsel, if I could ask you, how is the TMDL, the challenge action here is the TMDL. How is that causing the delay? How is that causing the harm that Abbott requires?
Your Honor, the TMDL is causing the harm because it is insufficient as a matter of law. Now, the TMDL that's been issued here today EPA has gone beyond its statutory authority in some stances. And as a result, both New Union has not implemented it effectively because they're challenging it here in court today. So the fact that this TMDL is not addressing the exact problems that TMDLs are supposed to, that's the concrete harm that makes this ripe for review. Now, with regards to the second factor, the next issue, the court should find that the EPA's TMDL in this case, which relied on BMPs to meet its goals, but had no reasonable assurances that the BMPs would be implemented, was arbitrary and capricious. Now,
given that we have tight time, I want you to go right to the fact, under the law, doesn't EPA have the ability, only have really control over point sources? They don't have direct control over non-point sources.
Correct, Your Honor. Now, EPA does not have direct authority to regulate non-point sources, but there are enforcement mechanisms that EPA can undergo in order to indirectly regulate those non-point sources. They can file civil actions against non-point sources. They can withhold federal funds. There's a variety of ways that the EPA can indirectly regulate those non-point sources, but they don't have the authority to directly regulate them.
So, Counselor, if I could follow up to that question, because again, we know time is tight, but about the reasonable assurances part of it, your argument is that EPA's decision to provide credit for reasonable assurances granted in a BMP to meet the TMDL, sorry for all the acronyms, but you know them so well, that's arbitrary and capricious. So the arbitrary and capricious standard is the most deferential standard for EPA. And if you could just go right to one of the State Farm factors that you think the standard doesn't meet or isn't met.
Yes, Your Honor. Under State Farm, when an agency has issued their own interpretation of their own regulation, and then they depart from that interpretation, they're required to articulate a reason for doing so. In fact, State Farm even held that an agency that changes its course by rescinding an interpretation is obligated to supply a reasoned analysis for that change beyond that which they might do in the first instance. Well, that's exactly what's happening here.
Pardon me,
yes,
I think if we're talking about interpretations, then we're in Chevron land or our land, AUER. Do you think we're in Chevron standard or applying an our standard to the reasonableness determination that EPA made here?
Your Honor, Chevron, I believe, applies to the reasonableness of statutes. Our would be the reasonableness of the regulation. So we would be more in our land.
What standard applies to EPA's decision here to rely upon reasonable assurances for meeting the TMDL?
The State Farm standard, Your Honor, is what would apply. The standard that requires EPA to articulate a reason for departing from their own interpretation. Now, EPA has had the interpretation that not only reasonable assurances would be required, but that all non-point sources should be subject to BMPs for decades now. As you said,
yes, this is Judge Lynch. Where is that interpretation laid out by EPA? It's not in a regulation, is it?
No, Your Honor, that interpretation was laid out in their 1991 guidance document. And that guidance documents are issued by the EPA on an official level to show their interpretation.
And counsel, are you saying, excuse me, are you saying that as a legal matter, this court owes any deference to guidance that was not promulgated through notice and comment rulemaking?
Your Honor, you're right. That guidance document did not go through notice and comment rulemaking, but the standard that the court needs to apply is the State Farm standard that requires EPA to articulate a reason for departing from their own interpretation after years of precedent that aligns with that interpretation.
Counsel, what's your best case for applying State Farm to have us overturn EPA's decision to base the TMDL on reasonable assurances?
Your Honor, the best case is that the math doesn't line up here. Now, the TMDL requires a 35% reduction from 180 megatons that are being emitted into this lake. That requires that 63 megatons of phosphorus are eliminated, and that requires relying on BMPs for non-point sources. And because they didn't ask for reasonable assurances, that was arbitrary and capricious. I see my time has finished. May I briefly conclude? Your Honors, for all the reasons that have been said just now, the use of a BMP credit in this TMDL without following their own interpretation and articulating a reason for that departure was arbitrary and capricious. And with that, I turn the remaining two issues over to my co-counsel, Ms. Foster.
Thank you, Ms. Johnson. Your Honors, today I'm going to talk with you about two questions of statutory interpretation. It's Chesapeake Lake Watch's position that, one, EPA's phased-in annual approach is impermissible under the Clean Water Act, but that, secondly, EPA's requirement of waste load and load allocations in this TMDL was permissible.
Counsel, I'm going to go right to the issue of the permissibility of the phased-in approach. I mean, we're talking about a natural ecosystem, and frankly, we're talking about the United States Environmental Protection Agency, which has deep expertise in the science. What precedent and authority can you offer that this court should substitute our judgment for the scientific expertise of the agency? If the agency determined that a phased approach would be effective, why would we second guess that?
Your Honor, for two reasons. The first is that it's clear in the statute itself that that total maximum daily loads need to be implemented in an expeditious way. Secondly,
is the word expeditious in the statute?
Yes, Your Honor. The word expeditious is found actually in the general purpose of the Clean Water Act in section 101A7, which specifically—
But not in 303D or 303E.
No, Your Honor. Okay. No, Your Honor. But we also invoke here Friends of the Earth versus EPA, the DC Circuit case that found that a phased-in approach was not permissible. But we aren't substituting policy judgments here. It's just EPA is precluded from making a policy judgment here because Congress has directly spoken to the issue here. A phase-in is not allowed under the plain language of the statute itself.
What piece of the statute are you citing? I have it here, and I would like to know exactly what piece of the statute you say prohibits this approach.
Yes, Your Honor. We have two different parts of the statute we believe speaks to this. The first is Section 301, B1A, which specifies that there must be achieved not later than July 1st, 1977, effluent limitations for point sources, but goes on to say in Section 301, B1C, that there shall be achieved by no later than that same date any more stringent limitation, including those necessary to meet water quality standards. Now, TMDLs are such a limitation that are set at a level necessary to apply or to reach those water quality standards. So we believe that these deadlines also apply to total maximum daily loads. And therefore, any TMDL that is issued must be achieved as fast as reasonably possible. And Your Honors, the second, we also point again to the main purpose of the statute, which also stated that it's the national goal that the discharge of pollutants into the navigable waters be eliminated by 1985. And at, again, A7, that it is the national policy that programs for the control of non-point sources of pollution be developed and implemented in an expeditious manner so as to enable the goals of this chapter to be met through the control of both point and non-point sources of pollution.
Well, counsel, can I ask you a question? This is Judge Lynch. By tailoring TMDLs to best regulate the discharge of a particular pollutant, in this case, phosphorus, which everyone acknowledges is not amenable to daily limits, why is EPA not satisfying the Clean Water Act's directive to restore and maintain the integrity of the nation's waters? It's Clean Water Act 101A.
Yes, Your Honor. And we do believe that the statute does provide some discretion for EPA to tailor its total maximum daily loads to help meet those standards. But at the same time, there's specific language, and in fact, in total maximum daily load, as you're referencing, daily itself, that is so unambiguous that it is a limit on what EPA can use.
Well, counsel, if I could ask you again, isn't the Clean Water Act silent on whether there's another time frame that may be used that would be more appropriate? I don't see language that's a prohibition in the statute.
Your Honor, are you referring to the annual and daily issue or the phase-in here?
Either one. Show me. I'm not seeing anything in the statute that prohibits another time frame.
Yes, Your Honor. As to phase-in, there is no express prohibition as to the use of any particular phase-in approach or time limit. But we do believe that those deadlines indicate the clear will of Congress that TMDLs be established and implemented as fast as reasonably possible.
We also follow up on that, if I could, as fast as reasonably possible. Is that the language from the statute?
No, Your Honor.
Okay, so let's follow up on that. I mean, isn't there a good argument that the statute actually contemplates phasing in these requirements? You know, the entire 303D section is written as a process. The states are first supposed to, based upon establishment of water quality standards, which is an initial step, and then identify waters that don't meet those standards, and then establish total maximum daily loads for those waters that don't meet the standards, and then develop water quality based effluent limitations to incorporate the waste load allocation, for example, and then put that into a permit, and then. I mean, doesn't that all, oh wait, and one other piece I just forgot is, and that be implemented through a continuing planning process that's contemplated and spelled out in the very next section. Doesn't that all contemplate a phased-in approach?
Yes, Your Honor. It certainly indicates a long and frankly tedious process in order to get each of these water bodies that are impaired back to their natural states. But these deadlines that are in the statute itself cannot be administratively extended. We found that in Bethlehem Steel Corps.
Counsel, I don't mean to interrupt you, but are you suggesting that the congressional dates, the early dates that have been long past, are applicable to today's activity? That we're dealing with a situation of unachieved statutory goals?
Yes, Your Honor, that's exactly right.
And then with regard to the TMDL, what about the cooperative federalism approach, where we have the state that is going to actually be doing this work, the state of New Union? They need time, they need resources, they need scientists. This water body will not be restored overnight. It will take a decade. It will be tedious.
Yes, Your Honor. And here we understand the state's position and their need to take into account all the different stakeholders, all the different costs. But we believe that EPA's specific setting of a 5-year extension of this deadline was not, if we make it to Chevron step 2 in this case, we also believe it's unreasonable here, although we believe it's precluded by the language in the statute itself. Setting a deadline, yes, Your Honor.
Then let's pivot over to the other argument, because I'm wondering about how to harmonize these two, how to reconcile these two, because you were arguing that we should not defer to EPA's interpretation of Section 303D, except to the extent that we should defer to EPA's interpretation of Section 303D. So when it comes to waste load allocations and load allocations, you're on EPA's side. You think that that's a reasonable interpretation, but there's no statutory basis for dividing a TMDL into those component parts of a waste load allocation and a load allocation. So how do you reconcile those positions?
Yes, Your Honor, you've identified that tension very well. And here, when we look to the waste load and load allocation requirement, we specifically look to the word total in total maximum daily load. And where daily is unambiguous in the context of total maximum daily load, we find total to be ambiguous. Your Honor, maximum daily load.
Counsel, isn't there case law that actually addresses the meaning of the word total? And that is a plain language. I believe there was a case that talked about, you know, a prayer for daily bread did not be a prayer for seasonal bread, right? So daily is plain statutory language.
Yes, Your Honor, we agree. Daily is plain statutory language. We disagree in that we don't believe that total is plain statutory language. And here specifically, some of that ambiguity comes from a few different factors. First, Congress could, here, maximum daily load would mean the same thing as total maximum daily load, unless total is read to add some meaning to the statute. And here, plausibly, that is the sum of the constituent parts of the loads.
Well, counsel, this is Judge Lynch. Then why does Congress in other parts of the Clean Water Act, namely Section 204B1 dealing with grants for treatment works, very specific? They require the agency to consider total cost of O&M, but they delineate, you know, the factors that are to be accounted for: wastewater loading, the actual constituent elements of the waste. In 303D, there's no such direction to provide a listing of loadings in the total.
Yes, Your Honor. And here we find that the language that's helpful is Section 303D's directive that TMDLs be established at a level necessary to implement the applicable water quality standards with seasonal variations and a margin of safety, which takes into account any lack of knowledge concerning the relationship between effluent limitations and water quality. A mouthful that to us shows that EPA was intended to have discretion to require states to submit total maximum daily loads in a way that would be protective of water quality standards.
Counsel, pardon me for interrupting again, sorry. But then doesn't the passage you just read, or that you just shared with us, doesn't that argue against your other argument? You know, doesn't the idea of seasonal variations and margins of safety to account for you know, what's not known suggest that EPA's decision to engage in a phased-in approach is reasonable?
Your Honor, we do not believe that that is so, because the statute is so clear as to the deadlines that were originally set out, which show how quickly this needs to be done. Additionally, there's nothing in the record to show any basis for why EPA has chosen a phased-in approach in this case.
There's nothing in the record, counsel, that supports the fact that to achieve phosphorus reductions in EPA's scientific judgment is going to take a period of time and control of many different inputs.
Yes, Your Honor. We and Chesapeake Plain Lake Watch understands that it will take time. We believe, however, that even at the time of approval, the phase-in established is by definition a gradual and not expeditious approach, and that there's nothing on the record at the time of decision to show that a 5-year approach is as fast as reasonably possible. And therefore, we believe the court should affirm the lower court's decision for Chesapeake Plain Lake Watch and find that an annual phased-in TMDL for phosphorus in Lake Chesapeake, given all that we have, the statute and the record, is contrary to the legal requirements of the Clean Water Act. EPA needed to have justified this at the time, and they did not.
Well, counsel, this is Judge Lynch, didn't they justify it by saying that their approach is more effective? And doesn't that line up with Clean Water Act 101 goals of restoring water quality?
Your Honor, the record does not show that EPA provided a reasoned basis for using the phase-in approach or for using an annual load when the statute itself clearly says daily and clearly had these statutory provisions indicating how quickly they needed to be carried out.
But doesn't the record support EPA's conclusion that their approach is more effective for phosphorus?
Your Honor, it's Chesapeake Plain Lake Watch's position that the record does not show that. But even if it did, EPA's preferred policy approach couldn't supersede the direct will of Congress in this case. And that is why we believe that the lower court should be affirmed on this issue. Now, Your Honor, moving on.
Follow up with that too, if I could. And we realize that for the moment you're sort of carrying, or your team is carrying EPA's water, no pun intended, but let me get your thoughts about the standard of review. The idea of waste load allocations, margins of safety, seasonal variations, that doesn't have, as you agree, doesn't have any statutory basis, but it's based upon a guidance document that EPA published some 30 years ago. It's not a rule, right?
Yes, Your Honor. A guidance document is not a rule.
Right, it's not a rule. And so why should we afford it Chevron deference instead of a lower form of deference like from Skidmore or Meade?
Your Honor, the questions here, Your Honor, you still need a reason for changing, for EPA to change its position. Your Honor, I see I've run out of time. May I briefly conclude?
Yes.
Thank you. Your Honors, this is a case about our community's once pristine body of water that has been defiled for too long. In order to protect the environment, the community, and for all the reasons we discussed, we ask that you find in favor of Chesapeake Plain Lake Watch. Thank you.
Thank you, counsel.
Thank you.
Counsel Nicholson on rebuttal. Welcome back.
Good afternoon, and may it please the court. My name is Haley Nicholson, and together with my co-counsel, Kassie Kometani, we will be representing the appellee, the State of New Union. With the court's permission, I would like to reserve 1 minute for rebuttal to be taken from my co-counsel's time. Your Honors, the Clean Water Act preserves carefully crafted cooperative federalism principles. This case regards how EPA has disrupted this balance and how EPA now attempts to dismiss this suit by ignoring the hardship that the state is statutorily obligated to face. With that in mind, I will demonstrate that this court should affirm the district court's holdings, that this case is ripe for review, and that EPA's interpretation of total maximum daily load is contrary to law. In the event—
let's go right to the ripeness issue. This TMDL essentially is pending implementation. It has not affected any particular permits. In fact, you might address for me the state's delay in renewing some of the point source permits. How do we have ripeness when the document is still in the queue, so to speak?
2 points, Your Honor. First, the state has acted with regard to the permits. The record indicates that the state has already proposed permit conditions for the point sources in Lake Chesapeake in conformance with EPA's TMDL. And secondly, here, the important question is the fact that the state is forced to modify its behavior in conformance with the federal TMDL under the threat of adverse consequences. To clarify,
let's focus on that, because we focused with the plaintiffs, we focused on fitness a bit. So let's focus on hardship to the state of New Union. What's the hardship in holding on, or what's the hardship to state of Union now? Because it hasn't yet issued these permits, or they've been administratively extended, but the state will be in a position to, to issue them in final form later. What's the hardship right now as this process continues?
The state's hardship right now is that it's forced to alter its traditional state functions regarding the implementation process.
Pardon me, Council, which hasn't happened yet. Has the state amended its 303E continuing planning process?
The record doesn't indicate whether the state has amended its continuing planning process. However, the state has proposed permit conditions in line with EPA's federal TMDL.
Okay, and that, pardon me, again, time is short. So to follow up on an earlier question from Judge Lynch, which gets to the area-wide treatment plans under Section 208, has the state updated that?
The record does not indicate whether the state has updated that. However, here, the important point is that the state has forced to change its traditional functions of making the allocations itself and formulating its own implementation plan. The statute requires the state to make the implementation plans and thus the allocations, not the EPA. Here, EPA's claimed authority alters that traditional state function under the distinct threat of three adverse consequences. First, EPA could deny the state funding. Second, EPA may withdraw authorization under Section 402. And third, EPA could require more stringent point source allocations and deny proposed permits.
Counsel, this is Judge Lynch. If I could ask you, none of those sound concrete to me, as Abbott calls for. They sound tentative and they sound far into the future, and far into the future because of your own inaction in issuing NPDES permits or even implementing BMPs. How do you meet the second factor called for in Abbott?
2 points, Your Honor. First, to clarify, imminent is regarding whether something is fairly certain to occur and not just speculative, rather than a timeline. The Supreme Court clarified this definition in Clapper versus Amnesty International, holding, quote, although imminence is concedingly an elastic concept, it cannot be stretched beyond its basic purpose, which is to ensure that the alleged injury is not too speculative for Article 3 purposes.
Well, how elastic is it? I mean, 10 years? I mean, we've all seen NPDES permits administratively continued for quite some time.
Mm-hmm. Your Honor, there is no need to have any kind of evidence before this court. The EPA will take action immediately. In Abbott Labs versus Gardner themselves, the court found that hardship would be found where plaintiffs were forced to alter their behavior under the threat of enforcement. The court didn't require evidence of actual enforcement plans, rather finding the threat of penalties sufficient. So too here, the threat of those statutory consequences is sufficient to find hardship.
And counsel, has EPA issued a threat to the state?
No, Your Honor. But again, the evidence of the threat is not necessary for hardship. And in any event, because this is a prudential doctrine, a stronger showing of hardship is not required. As the DC Circuit held in Southwest Power Pool versus FERC, quote, a showing of hardship is ordinarily unnecessary, where the agency has suggested no institutional interest in postponing review, and adjudication will not benefit from additional facts.
Well, counsel, aren't you asking this court to disregard precedent and agreement that these TMDLs are merely providing you, the state, with valuable information?
No, Your Honor. The state here is requesting that this court find this case to be ripe for review, and that is in line with precedent. The only two courts to decide this precise issue, the Third Circuit in American Farm Bureau and the Eighth Circuit in City of Kennett, both found that the mere adoption of a TMDL forces states to spend more time, energy, and money. Therefore, under the threat of adverse consequences, there would be a ripe case. And so too here, this case is ripe for review. Now,
Counsel, I'm pleased that you brought up the American Farm Bureau Federation case. How is that factually different from the situation with Lake Chesapeake?
Your Honor, to clarify, are you requesting difference regarding the issue of waste load allocations and load allocations, or a factual difference?
Just factually, the body of water at issue, it's an important precedent for what we're talking about here today, but I think it's different also than what's going on in Lake Chesapeake.
Yes, Your Honor. The difference between this case and Lake Chesapeake, this case and the Chesapeake Bay TMDL, is the body of water in the American Farm Bureau case was the largest estuary in North America. Here, in contrast, we're dealing with a purely intrastate lake that's only 55 miles long, and hence we're faced with more serious federalism concerns that were not present in the American Farm Bureau case. Here, EPA's interpretation of total maximum daily load is contrary to law. Section 303D1C requires that the state establish the total maximum daily load at a level necessary to implement applicable water quality standards. This is a plain meaning issue that should be resolved at Chevron Step 1.
Counsel, pardon me, before we move on to that issue, and I'm anxious to get there as well, but I'm wondering about two things. First, you referred to the Clapper case earlier. Is that a ripeness case?
No, Your Honor, that case dealt with imminence under the constitutional doctrine of injury. But here, the important part is that imminence means the same thing under the ripeness doctrine as it does in the constitutional doctrine for injury.
So the Clapper case, which is fairly recent, the Supreme Court has applied that standard in the ripeness context, that same word, the Clapper standard?
The Supreme Court has required imminent hardship, such as in Abbott Labs versus Gardner. And there, similarly, they didn't require a timeline. They didn't expressly address this issue that imminent means one thing versus another. But in that case, the Supreme Court did hold that the threat of enforcement was sufficient and that there wasn't a necessary timeline for hardship to be evident.
Okay, well, yeah, all right, thank you. Then let's talk about the Abbott Labs case that you just mentioned. In the Abbott Labs case, the pharmaceutical industry company was sort of given what's called a Hobson's choice. Mm-hmm. They either comply and spend all of the millions of dollars to transform their processes and labeling and so on, or they don't, and they can be subject to criminal penalties and prosecution. What's the Hobson's choice that the state of New Union is facing?
Here, Your Honor, the state is forced to alter its behavior of traditional state allocation and implementation under the threat of adverse consequences. And this case is similar to the Supreme Court case of Columbia Broadcasting versus United States. And there, the Supreme Court found that the mere fact that they could lose a license was sufficient to find hardship. And so too here. Therefore, this case is ripe for review.
Thank you, counsel.
Returning to the merits, counsel for CLW improperly jumped to the canon against surplusage rather than applying the plain meaning of total. The plain meaning of total is constituting a whole. So a total maximum daily load defines the maximum amount of pollutant that can be discharged or loaded into the waters at issue from all combined sources.
Well, counsel, why isn't another way to read total as the sum of the different parts? And in this case, waste load allocation, seasonal variations, and margins of safety.
Your Honor, that's because of statutory context. The plain meaning of total to mean constituting whole is confirmed by the surrounding language of the phrase and the singular tense of the phrase. Notably, Section 303D requires that the load be established, quote, at a level necessary to implement applicable water quality standards, not levels, but the singular level. And here, a total maximum daily load does just refer to that number. And as
counsel, I actually do share the concern about you asking us to run afoul of the canon against surplusage. So in other words, where one reading of a statute would make one or more parts of the statute redundant and another reading would avoid the redundancy, the other reading is preferred. I'm concerned that your reading of total renders total redundant. And by that, I mean maximum daily loads established at a level necessary to implement the applicable water standard would mean the same thing that you argue total maximum daily load means, a number set at a level needed to alleviate water pollution. But, you know, as discussed in the American Farm Bureau Federation case, the Third Circuit, why shouldn't we apply the canon against surplus and find that a plausible understanding of total is that it means the sum of the constituent parts?
2 points, Your Honor. First, contrary to counsel for CLW's assertions, total is not surplusage because it has a separate and independent meaning from maximum. Total refers to the congressional recognition that TMDLs encompass all sources. Maximum, on the other hand, reflects the volume rather than the number of sources. But even if this court disagrees with total having an independent meaning, the canon against surplusage is not absolute. In Lamy versus US Trustee, the Supreme Court held that, quote, surplusage does not always produce ambiguity, and our preference for avoiding surplusage constructions is not absolute. In that case, similar to here, the court noted that the plain meaning interpretation would result in surplusage. The court found, quote, we should prefer the plain meaning since that approach respects the words of Congress. So too,
and counsel, can you show me where in the Clean Water Act total maximum daily load is defined? Are there definitions for each of those words?
No, Your Honor. However, as the DC Circuit noted in NRDC versus EPA, quote, the absence of a statutory definition does not render a word ambiguous. And as the Supreme Court noted in FCC versus AT&T, where a statute does not define a term, the court must give the phrase its ordinary meaning. Here,
please finish your sentence, then I have a question for you.
Here, that ordinary meaning means to constitute a whole, and thus a TMDL is just a number.
So counsel, I'm following you and wanting to give credence to your argument. I am looking though at the text of 303D, and it very specifically talks about what shall be included in the TMDL. There's all sorts of words, as Judge Lynch has suggested. There's seasonal variations, heat input, the capacity of the water, calculations. It appears that Congress thought quite deeply about what should be in a TMDL.
While there are these different parts of a TMDL, that does not negate the plain meaning of total. A whole number can still account for seasonal variations with a margin of safety. And therefore, this court should adopt the reasoning that a TMDL is just a number. Additionally, this court
Counsel, I have a question. These TMDLs are promulgated with notice and comment. Doesn't EPA have to explain how they arrive at the total? They have to explain the waste loads and the load allocations. How is the public supposed to evaluate and comment on the TMDL?
Your Honor, notably, EPA does not actually create the sum from the constituent parts, and therefore it would not fall against this EPA standard for the EPA to require just a number. EPA has actually released guidance for developing nutrient TMDLs that specifically states that a total load should be derived before the allocations, and therefore the total is not the sum. And here, EPA's interpretation is beyond the scope of ambiguity. EPA applies a definition of total that even they don't contend is in the dictionary, and thus
But counsel, how does that address the APA issue, the notice and comment and transparency issue?
I see that I'm out of time. May I briefly answer your question? EPA can still decide how to explain its TMDL, even if it's just a number. And that's because it does create that sum before the constituent parts and has the science to back up how they reach that whole number before dividing it into allocations. And therefore, this court should reject EPA's unreasonable interpretation of the word total. Thank you.
Thank you, counsel.
Thanks.
Thank you.
Thank you.
May it please the court, my name is Kassie Kometani, and I represent the state of New Union. As my co-counsel just discussed, EPA's interpretation of total raises serious concerns by usurping state authority over non-point sources and disrupting the careful balance of cooperative federalism enshrined in the Clean Water Act. Those concerns are not present with the phased annual load reduction. So in the event that this court does find EPA's interpretation of total to be permissible, I will demonstrate that EPA's TMDL establishing a phased annual load reduction comports with the Clean Water Act, and that it was not arbitrary or capricious for EPA to adopt a credit for anticipated pollution reductions without reasonable assurances.
Counsel, let's just get right to that, if I could. Sort of getting back to the question that I had for plaintiff's counsel earlier about consistency, your co-counsel just made an argument about why EPA's interpretation of the term total to be these constituent parts of waste load allocation, margin of safety, background sort of thing, isn't reasonable. That it should just be, whatever the number is, it's just one number and it's just for informational purposes. Yet, your side argues, and we're about to talk about this phase-in, that has no statutory underpinning, that's somehow consistent with the statute. So I'm wondering how you reconcile your argument with the argument that your counsel just made.
Certainly, Your Honor. To address that tension, with Daly, the same federalism concerns that are present with EPA's interpretation of total are not present. And statutory context makes clear that Congress intended for the effective regulation of pollutants through a TMDL, and that may require an annual load or a phased annual implementation plan. EPA's establishment of a TMDL with
Pardon me, excuse me for interrupting again. You said the statute accommodates a phased approach. At least by my reading, I don't see the word phased anywhere. I don't see it in section 101, which declares that the objective of the Clean Water Act is to preserve and maintain the chemical, physical, and biological integrity of the nation's waters. I don't see it in section 301 about water quality standards, or 303 or 30. You get the point. So what's the statutory basis for, textual basis for phased approaches?
Your Honor, it is correct that there is no exact textual basis for allowing a phase-in. However, EPA believes that in order to set a TMDL that implements the applicable water quality standard, it makes sense to allow for a 5-phase-year period. Section 303D does not specify an exact time frame during which a TMDL must prevent violations, and counsel for CLW even admitted that timelines are allowed. The statute only specifies that a TMDL be set at a level necessary to implement the applicable water quality standards. Counsel for CLW also cites to section 301B1A, which has nothing to do with water quality-based effluent limitations. Furthermore, no court has held that the statutory goal of the Clean Water Act applies in a substantive way. There is no applicable deadline for TMDLs.
Well, counsel, how do you distinguish Natural Resource Defense Council versus EPA case in the plain meaning of the words maximum load?
Your Honor, could you please rephrase your question?
Yes. The court in Natural Resources Defense Council versus EPA, U.S. District Court, DC 2018, found that there was a plain meaning to the words maximum load that contradicts EPA's approach and your approach for allowing load limits that in effect increase incrementally over time. How do you distinguish that case?
Here, Your Honor, statutory context makes clear that Congress intended for the effective regulation of pollutants in order to achieve water quality protection. Under that statutory context, a phased-in 5-year annual TMDL
So, counsel, if I could just interrupt because of time. So you're saying that maximum load does not have a plain meaning?
It may, Your Honor, but in terms of daily loads, that does not have as a plane of a meaning given the statutory context. And that's exactly what was found by the Second Circuit and Natural Resources Defense Council v. Musinski, which applied the fundamental statutory scheme canon and held that daily is susceptible to multiple meanings since non-daily terms may better serve the purpose of effective regulation.
Well, counsel, why didn't Congress use more flexible language or just said total maximum load?
It could have, Your Honor, but that daily term indicates that a TMDL must be set in a time frame. So what EPA is doing here isn't attempting to read daily out of the statute. They're simply making the case-by-case determination that an annual load is most appropriate. As the Supreme Court discussed in U.S. v. Hager Apparel, Congress likely cannot anticipate all of the circumstances in which a general policy will be given effect.
Well, counsel, let's put policy aside for a moment. In 1978, didn't EPA in the Federal Register find that all pollutants are amenable to daily TMDLs?
That is correct, Your Honor. But again, EPA's TMDL here is setting an annual load to meet the relevant requirement, which is setting a TMDL that implements the applicable water quality standard. And that was a reasonable determination here. As the Supreme Court aptly noted in Baltimore Gas v. Natural Resources Defense Council, when examining an agency's scientific determination in its area of specialized expertise, quote, a reviewing court must generally be at its most deferential, end quote. As Judge Dunn also recognized, EPA is well suited to make decisions of this complexity and has a scientific expertise to determine whether an annual limit is most effective for implementing a water quality standard. And this
counsel, if I could
sure, go ahead.
Ask quickly, sorry, go ahead.
No, please, thank you.
Counsel, how do you respond to Chesapeake Lake Watch's argument that the Clean Water Act's 1977 deadline for achieving effluent limitations necessary to meet water quality standards undermines your position?
The 1977 deadline for limitations in Section 301B1C does not directly apply to TMDLs and does not require that TMDLs calculate immediate compliance with water quality standards. In 2019, the Fifth Circuit rejected a similar argument in Clean Water Action v. EPA when it held that it would be absurd to require compliance with technology effluent limitations deadline in Section 301B2C, both within 3 years and by the 1989 deadline. There, the court agreed with EPA's natural reading of the deadline included in the text, which made it clear that only initial effluent limitations needed to both adhere to the 3-year compliance deadline and be achieved by 1989. There, the Fifth Circuit upheld EPA's 5-year postponement rule without any hesitation or discussion.
You mentioned, counsel, a 5-year postponement rule. Regulation. Are we talking about something that was done through regulation here?
No, Your Honor. We are talking about a 5-year phase plan. But again, there is no applicable statutory deadline that requires a TMDL to contemplate immediate compliance. And while the statute is silent.
Pardon me, if I could just ask you about that. Again, I know time is short. I'd like to push back on that a little bit. You know, the Clean Water Act this fall will be celebrating its 50th year. And when Congress enacted it, it had these 2 basic purposes: to make all waters fishable and swimmable by 1977. I think that's right. But and also zero discharge by 1985. How does, getting back to our standard of review, because we're judges, that's what we have to apply. Even if even if we agree with a certain policy position, we still have to abide by Article 3 and the Administrative Procedure Act and so on. How does your argument meet those objectives that Congress has set up?
It meets the objective, Your Honor, since this 5-year plan is a prompt response to the problem at hand. So again, while the statute is silent on immediate compliance, in a different yet relevant context, the Supreme Court in Weinberger v. Romero-Barcelo stated that temporary non-compliance was acceptable since the Clean Water Act still ensures prompt compliance. So in the absence of an applicable statutory deadline, the Supreme Court has clarified that courts can still ensure prompt compliance. And that's exactly what this 5-year implementation plan represents.
Pardon me, was that a TMDL case?
It was not, Your Honor. It was a permitting case. But the salient point from that case is that in the absence of an applicable statutory deadline, courts can still be assured that they can ensure prompt compliance. The Third Circuit has actually upheld a similar implementation plan in a TMDL case in American Farm Bureau, where the Chesapeake Bay TMDL set a target date 15 years into the future. That target date was not challenged in the case, but the court did state that promulgating an accurate TMDL requires the consideration of a timeline, given the dynamic nature of watersheds. EPA's TMDL is even more stringent and sets year-by-year reductions to ensure that sources are on track to implement the applicable water quality standards.
Cut in again, and maybe I won't again, but pardon me. But our standard review isn't whether something is reasonable to do. It's whether it's a reasonable interpretation of the statute. So what I'm very curious to hear your thoughts about is how this phased-in approach is a reasonable interpretation of the language of the statute. Thank you.
Certainly, Your Honor. The relevant language in the statute in section 303D is that TMDLs must be set at a level necessary to implement the applicable water quality standard. What is lacking there is a deadline to achieve that goal. And with that ambiguity there, with that gap, EPA has decided that a 5-year phased plan is sufficient to implement the water quality standard. And that's how it continues to comport with the Clean Water Act.
And Council, are there regulations that that EPA has implemented for 303D that might be helpful to your position here?
Yes, Your Honor. EPA's regulations contemplate that permits may specify schedules of compliance. Once this phase implementation is incorporated as a schedule of compliance in the permit, adherence to that schedule will be deemed adherence to the statute.
Is there a TMDL set of regulations? A set of regulations to implement 303D, the TMDL program?
The TMDL program is implemented under section 303E, Your Honor, which again does not have an applicable statutory deadline requiring immediate compliance.
Right, but in terms of implementation under E or creation under D, are there regulations that speak to the issue of a phased approach?
Not that I'm aware of, Your Honor, no. Next, on reasonable assurances, just as EPA lacks authority to require waste load and load allocations in a TMDL, it also lacks authority to require reasonable assurances. As Judge Dunn aptly noted, EPA does not have authority over non-point sources. The 11th Circuit discussed in Sierra Club v. Mayberg that the Clean Water Act leaves the regulation of non-point source discharges to the states through the implementation of TMDLs. Furthermore, the 9th Circuit noted in Pronzolino v. Nastri that, quote, there is no pertinent statutory provision otherwise requiring implementation of Section 303 plans or providing for their enforcement, end quote.
Let me cut in here about this issue, about reasonable assurances. It raises different questions of our standard of review. The way I understand it is our standard review for this issue, as has been argued, is State Farm. Do you agree with that?
Yes, Your Honor.
Okay, so then what State Farm factor has EPA not met in its determination to provide credit based upon reasonable assurances to meet a TMDL?
Your Honor, we do believe that the State Farm standard has been achieved, and EPA's decision to not include those reasonable assurances here is not arbitrary or capricious, since the agency has other mechanisms in place to ensure compliance. The agency has not required reasonable assurances in every instance, since at all times the agency retains the ability to make a case-by-case determination and ensure compliance with the water quality standard. For example, EPA did not obtain reasonable assurances from all of the states in the Chesapeake Bay TMDL at issue in American Farm Bureau. Instead, EPA imposed a backstop adjustment by requiring greater reductions from point sources if certain sources could not meet their projected load allocations. So EPA recognizes that there are other mechanisms in place to ensure compliance, and those same leverage points would apply here. Thus, the agency's determination to not require reasonable assurances was not arbitrary or capricious.
So I see we're out of time here, so let me let you conclude.
Thank you, Your Honor. Sitting as the fact finder below, the district court made clear that its inquiry was focused on whether EPA considered the relevant factors and gave a reasonable basis for its decision. Thus, this court should uphold the district court's determination, finding that EPA was not bound to apply a reasonable assurances requirement when evaluating best management practices for credit trade-off. Thank you.
Thank you.
Thank you, Council. Let me just make sure we're ready to proceed, Council. We are ready? Yes. Council, please proceed.
Good afternoon, Chief Judge, Your Honors, and may it please the court. My name is Lauren Beams, and I, along with my co-counsel, Ms. Emily Witthoeft, represent the United States Environmental Protection Agency. Chief Judge, at this time, the EPA would like to reserve 1 minute for rebuttal. My co-counsel, Ms. Witthoeft, will address issues 3 and 4 regarding the phased-in annual reduction and the BMP credits, but I will first discuss issue 1 regarding ripeness, and then issue 2 regarding the EPA's interpretation of total maximum daily load. So turning to that first issue regarding ripeness, EPA respectfully requests this court determine that this case is not ripe for judicial review for 2 reasons. First, the case does not satisfy that fitness requirement. And second, the parties would not suffer a hardship if this court withheld its decision. Your Honors, all parties here today have the same goal of clean water, specifically helping Lake Chesapeake. It's just a matter of how to get the clean water and when to implement various regulations.
Counsel, can I interrupt you and get you to explain to us how this issue does not fit the fitness for review? I mean, do you disagree that the TMDL is a final agency action?
Your Honor, yes. The EPA disagrees that the TMDL is a final agency action, and that finality requirement is key to determining whether or not a case is fit and thus ripe for judicial review. This action here, the TMDL, is just an informational tool.
Counsel, if I'm not following. I'm talking about the posture of the TMDL. Did EPA issue the TMDL following notice and comment rulemaking?
Yes, Your Honor, EPA did that.
And you do not consider that a final agency action under the APA?
No, Your Honor, not when considering the TMDL implementation process, like the Section 303E continuing planning process that the TMDL has to be implemented in, and then the EPA—
Isn't that a separate process? I'm talking about the TMDL itself.
Yes, Your Honor, but the TMDL is just an informational tool. It's information given to the state on how best to have a water body, an impaired body of water, come into compliance with water quality standards. And then that TMDL, that informational tool, will be implemented into that continuing planning process under Section 303E that the EPA must then approve or disapprove as well.
Well, Counsel, what further factual developments are necessary? I mean, the means of implementation is clear: permit limits and BMPs.
Yes, Your Honor. So perhaps the factual element is final, and this is a legal issue. However, the state has yet to implement the EPA's TMDL, and until that TMDL is implemented, this case is not ripe for judicial review.
Counsel, is there a case law that helps you on the issue of finality for a TMDL?
Yes, Your Honor, there is case law. They both come from United States District Courts, City of Arcadia versus EPA and Bravos versus Green. And there, in both cases, the issuance or the approval or disapproval of a TMDL was not ripe for judicial review in those cases. Because factual development still needed to happen and the TMDLs were not yet implemented. And the state's TMDL is not yet, or the EPA's TMDL is not yet implemented into the state's implementation plan yet here.
Aren't there cases on the other side though?
Yes, Your Honor, there are. Like the Third Circuit in American Farm Bureau was found to be ripe for judicial review, absolutely. However, this is not the case in American Farm Bureau. This goes back to Chief Judge's question to opposing counsel, where how do we distinguish American Farm Bureau from our case here? In American Farm Bureau, there was no state TMDL to start out with. The EPA was implementing its own TMDL and the state did not have one. Here we have the state's TMDL. The EPA reviewed it, decided that it was inadequate for Lake Chesapeake, and then implemented its own. And that is different from the American Farm Bureau standard here. That also goes—
Does that raise issues around cooperative federalism, which may not be one of the issues that you plan to address, but I am concerned about the balance of delegated authorities to states and EPA's sort of second guessing the judgment of the state. with regard to Lake Chesapeake?
Your Honor, yes, it does go toward cooperative federalism. The EPA is given authority in Section 303D2 to approve or disapprove of a state's TMDL, and then if it disapproves, implement its own. But this, Your Honors, it's as if the EPA and the state are like co-pilots, right? The EPA and the state work together to fly a plane and make sure everyone arrives at their destination safely. But when the state is the pilot, it has primary control. But when the EPA as co-pilot sees that the state is flying at an improper altitude, the EPA can come in and readjust and fly it back into that good flight path. And the EPA is doing that here. It sees—
Council, let's talk about how EPA is doing that here. And again, I think it's interesting that you just use that analogy, because it sounds like, when the plane lands, it's a landing, it's a final action. So I'm still curious to hear how you reconcile that with Judge Lynch's question. But let me ask you a slightly different one. Based upon the facts here, this isn't like the other cases, Farm Bureau, Mazinski, and so on, because, didn't the state propose a TMDL and then change its mind or make adjustments after a public comment period? Isn't that right?
Yes, Your Honor, the state had a TMDL.
And then didn't, if I could, counsel, and then the state issued its final TMDL, which was different than its proposed TMDL, but then EPA disapproved that final TMDL and ended up issuing its own, which was just the same as the state's initial proposed TMDL. Isn't that right?
Yes, Your Honor, it is right that the EPA disapproved of the state's mere 120 metric ton TMDL, and it thus implemented.
So what's left on just in the ripeness side? I think that raises interesting questions about federalism that Judge Dunn asked as well, cooperative federalism. You just did exactly the same thing the state initially proposed. But on the ripeness side, what else is left to be decided on a factual basis? There was a notice and comment period. The public commented, the state issued a final rule, you reviewed it, you're done with it, you went back to its initial rule. Now it's just a question as to whether, how do we interpret the words like total and maximum and otherwise? What's the factual, getting back to Judge Lynch's question, the factual record that still has to be determined?
Your Honor, respectfully, the factual record is not much has to be developed anymore. The factual record is pretty secure. However, it does matter how the state implements the EPA's TMDL. And then at that point, it could be ripe for judicial review, but it's not ripe yet because this is just merely an informational tool for the state to then implement into its implementation plan. But this court—
Counsel, isn't it, excuse me, this is Judge Lynch, if I could interrupt. The district court below found that City of Arcadia and Bravos Green were in a positive because there, the permit limits were not clear. In our case, the permit limits are clear.
Yes, Your Honor, they are clear in the EPA's TMDL. However, they just haven't been implemented
So
yet.
So how did the district court below in our matter get it wrong? What was wrong about their analysis of Arcadia?
Your Honor, their analysis of Arcadia was wrong because the state's TMDL was not implemented yet in those cases. And it has not been implemented yet in this case as well. But if this court does find that this case is ripe for judicial review, this court can turn to the more substantive issues on the record, starting with issue 2, which has to do with the EPA's interpretation of total maximum daily load, as Judge May pointed out. So regarding issue 2, EPA—
Counsel, let me ask you about that then again, because we're tight on time, let me get right to it. So you've said a couple of times about how the TMDL is just for informational purposes. I think I'm using your language that I've heard twice. Isn't that exactly what the state is saying, that it's just a number and that EPA breaking it down into all these component parts isn't reasonable? I mean, doesn't that help their side?
Your Honor, 2 points to your question. The first is, yes, the EPA states that it's just one number, an informational tool. However, it would not be ripe for judicial decision, yet the state argues that this is ripe. Second, yes, the total maximum daily load must be allocated in waste load and load allocations. And the first way to see that reasonable interpretation is looking to the structure of Section 303D.
About that. Pardon me, please, but the standard of review, again, that's the role we're playing. We're applying standards of review. EPA argues that it's entitled to Chevron deference, but the breakdown of the TMDL into those component parts isn't in the statute, right?
Correct, Your Honor.
But it's in a guidance document that was published in when? 1991, is that right?
Your Honor, I'm unsure of that guidance document. However, the definition of TMDL was codified in the Federal Register in around 1985. And that goes with Congress giving the EPA authority to fill in those gaps when Congress leaves those gaps. And Congress left that gap here for the expert, the EPA, to come in and define total maximum daily load.
And that is a good point, Counsel. So can you tell me, what is that definition?
That definition, Your Honor, is the sum of individual waste load allocations for point sources, load allocations for non-point sources, and natural background. And that's in 40 CFR section 130.2I.
And is that what we have here in this TMDL? Do we have those pieces?
Your Honor, the EPA's TMDL does allocate for point source and non-point sources. However, the issue here is that EPA rejected the states for not including both waste load and load allocations because it saw the dire need of Lake Chesapeake to have just more than one number for its TMDL. This goes toward—
But the regulation that you just cited to me, did it require those pieces that you're now saying were deficient?
I'm sorry, Your Honor, which pieces?
The pieces that are missing, the waste load and load allocations, are they in the regulation? Are they required to be part of the TMDL and the definition that you cited to me?
Your Honor, they're required because it is in that definition, the regulation that the EPA defined, and that is the interpretation at issue here today. And so in requiring the sum of waste load and load allocations, the court must look to where TMDLs fall within this mechanism of bettering water quality. And that's after regulating point sources is not working. So the TMDL mechanism is implemented when a regulation of just point sources doesn't work. And so after that, it's imperative for the TMDL to account for non-point sources as well.
Counsel, doesn't the structure of the act make it clear that the TMDL is implemented by the state in 303E, separate from 303D? And by giving yourself the authority to allocate pollutant discharges, to particular point sources and non-point sources, isn't EPA undermining the cooperative federalism clearly envisioned by Congress?
Your Honor, respectfully, no, EPA is not undermining that cooperative federalism because it is given that wide discretion on determining whether or not a state's TMDL is proper for that impaired water body. 47.7% of the loadings calculated on pages 8 and 9 of the record came from non-point source discharges. The EPA saw that and determined that a TMDL for Lake Chesapeake must include non-point sources for Lake Chesapeake to have any chance of coming into compliance with water quality standards. As Chief Judge mentioned, correct, the EPA does not have direct authority over point sources, but the EPA does have that wide discretion. And so thus, Judge May also correctly stated that there's no statutory basis in splitting TMDL into waste load and load allocations, but Congress did give the EPA that gap to fill in. And following that gap, that definition, that interpretation only brings consistency to regulating water quality and furthers the maintaining the integrity of the nation's waters.
Well, there's only one definition in Webster's dictionary, and that's its one number.
Your Honor, I see my time has ended. Would you like me to respond?
Briefly.
Yes, Your Honor. It might be total is one number in Webster's dictionary, but in light of the overall statutory phrase, structure, and meaning, total maximum daily load can include both waste load and load allocations. Thank you.
Thank you.
Thank you.
Chief Judge, counsel for EPA is ready to proceed when the court is.
Thank you. We are ready. Please proceed, counsel. Thank you.
Thank you, Chief Judge. Good afternoon, Chief Judge, your honors, may it please the court. My name is Emily Witthoeft, and I also represent the EPA. And I will be addressing the third issue regarding the annual phased TMDL and the fourth issue regarding the BMP credits. Accordingly, the EPA respectfully requests this honorable court affirm en part and reverse en part the district court's order for two significant reasons. First, this court should reverse the district court's order with respect to the third issue on appeal because the district court erred in finding that the annually expressed phased TMDL violates the Clean Water Act. And second, this court should affirm the district court's order with respect to the fourth issue on appeal because the district court was correct in finding that the EPA's grant of BMP credits was not arbitrary and capricious or an abuse of discretion. So with respect to the third issue on appeal regarding the annually expressed phased TMDL, Your Honors, it's critical to emphasize that under Chevron, when a statute is silent or ambiguous with respect to a specific issue, the question for the court is whether the agency's answer is based on a reasonable interpretation of the statute. So in light of this, the district court erred in two major ways. First, the term of art total maximum daily load is ambiguous as to the specific issue of whether a TMDL can be expressed in terms of a phased annual load amount.
So counsel, let me interrupt you there. We've covered this with the other parties as well. So hasn't EPA over quite some time outlined how it will express TMDLs? We've referred to guidance document, regulations, and other procedures. The agency has looked at hundreds of TMDLs around the country. So the agency has been very consistent with its approach to how TMDLs are expressed. And they have included phased TMDLs.
Correct, Your Honor. Chesapeake Lake Watch's strictly daily argument actually blatantly conflicts with long-standing EPA regulations that actually allow states and the EPA to make a case-by-case determination about the suitability of pollutant for a daily load calculation, and actually explicitly states that daily loads only need to be calculated where the appropriate technical conditions exist to allow such calculation.
Counsel,
and here,
which
Your Honor,
regulation in particular? Sorry. Which regulation in particular?
Yes, Your Honor. That would be, it was a regulation that was adopted pursuant to a court order issued by the United States District Court for the District Court of Columbia in Board of Community Commissioners of Calvert County versus Coastal. And in fact, this same regulation was relied on in part by the DC Circuit Court in its 2006 Friends of the Earth versus Environmental Protection Agency, which Chesapeake Lake Watch actually cited to. But importantly, Your Honors, the EPA and the state of New Union have made a case-specific determination that given the volatile nature of phosphorus that Your Honors point out, a daily TMDL calculation simply is not practicable. Phosphorus is a naturally occurring nutrient.
Counsel, go ahead.
Counsel, please stop me on that just about what's practicable. At least the way that I understand the Chevron standard, it isn't about whether something is practicable or practical. It's whether EPA's interpretation is reasonable. So we have to look first at the plain language. So I'm wondering, is there any plain language in the Clean Water Act that gives EPA authority to use a phased approach for TMDLs?
No, Your Honor, there is no plain language in the Clean Water Act that permits the EPA to implement a phased annual TMDL. However, it is ultimately silent on this. And actually, when we're looking to apply the first prong of Chevron, we can't simply focus on the common dictionary meaning. Under the first prong of Chevron, courts actually have to, in order to acquire the plain meaning of a word, they have to apply the canons of statutory construction and construe a term in the broader context of the entire statutory structure of the Clean Water Act.
We can do that for a second then. Again, getting back to questions from both of my colleagues on the bench. The Clean Water Act, the statute has two subsections really that are in play here, 303D and 303E as my understanding. And 303D is the TMDL and E is the implementation part. So how is it a reasonable interpretation by EPA, which I think is EPA's argument, to import the implementing aspects of this exercise into 303D when they're right there in 303E?
Yes, Your Honor. So a part of implementing the TMDL plans does ultimately have to, when the state and the EPA work together to develop a TMDL, they have to consider the total maximum daily load that's allocated and how it is implemented. So in this exact scenario, the EPA decided that an annual allocation of the load limits and a phased implementation plan was the most reasonable approach, because not only given the nature of phosphorus, but it also recognizes and enforces cooperative federalism between the EPA and the states, which is a fundamental part of achieving the Clean Water Act's goal of obtaining clean water. And
Council, yeah, and also making waters fishable and swimmable by 1977. So two quick questions for you and follow up on that one. First, how does EPA's phased approach achieve that objective that Congress set 50 years ago? And then secondly, again, we're talking about what's reasonable in terms of interpretation, not in terms of policy, but how is it a reasonable interpretation to incorporate implementation into the language of Section 303D? Thank you, Council.
Yes, Your Honor. So to answer your first question with respect to the 1977 deadline requirement, we have to remember that the state of New Union was actually in compliance up until fairly recently with water quality standards. So the 1977 deadline is a little bit of a different situation where we're far beyond that point. So while, again, the TMDL does not ultimately, we can't go back in time and reverse what's already been done. What we can do is develop a plan that is effective and also respects the state's sovereignty over its own water bodies. And with that delicate balance, we can achieve proper water quality standards. It just has to be a practical approach. Now,
well, Council, if I could pause you there for a moment, putting aside reasonable interpretation and Chevron, going to your practicality argument. Very next year, 1978, how do you explain EPA's regulatory finding, all pollutants suitable for calculation of total maximum daily loads? You said it was practical. EPA said it was practical for all pollutants.
Your Honor, the EPA also issued promulgation that daily loads have to be determined based on a case-by-case basis. And when we are dealing with phosphorus, a daily load is just not the right approach. Again, phosphorus
Council, why didn't EPA change the 1978 regulation? Why didn't you update that?
Your Honor, I don't know the answer to that exact question. However, I do know that at least when it comes to approaching and achieving water quality standards, there's a lot of variables that need to be considered. Congress directs the EPA to approve TMDLs for hundreds of different pollutants and thousands of different water bodies, because the EPA is the expert in properly administering the Clean Water Act. So annual expressions of a total maximum load of a pollutant are optimal for some combinations of pollutants and water bodies, which is what we are seeing here with the phosphorus of pollutants. So daily loads cannot accurately account for the effect of phosphorus loading on the lake that we're dealing with here, because phosphorus concentrations in water bodies are affected by the interplay of, was there a question, Your Honors?
No, but thank you for pausing for a moment, because I will ask one. So I believe in the District of Columbia, there were nitrogen and phosphorus TMDLs that were reviewed, I believe, by the district court in DC for being only expressed seasonally. And the EPA's approach was to just calculate a daily number, but implement them on a seasonal basis. So checking the box essentially for the daily approach, but then carrying them out the way you might be suggesting that over a seasonal basis. Are you familiar with that precedent?
No, Your Honor, I'm not familiar with the exact precedent that you are discussing. However, I do know I am familiar with the Third Circuit Court of Appeals opinion in American Farm Bureau Federation versus the United States EPA, where they were dealing with a very similar situation that we're dealing with here, and not an identical situated lake, but however, the same exact scenario of interpreting whether or not total maximum daily load was ambiguous and allowed the EPA to implement a annual TMDL. And in fact, the court said exactly, quote, Congress was ambiguous on the content of the words total maximum daily load. They are not defined in the statute, and the Clean Water Act is silent on how the EPA must set the load. These factors suggest that Congress wanted an expert, here, the EPA, to give meaning to the words it chose, end quote. And likewise,
Counsel, what's ambiguous about daily?
Your Honor, when taken in isolation, the word daily is unambiguous. We agree to that. However, we cannot parse out these words and dissect them on an individual basis. Contrary to Chesapeake Lake Watch's belief, courts must employ the canons of statutory construction when tasked with determining whether a statute is silent or ambiguous.
And
with
what's
respect.
ambiguous about maximum and what's ambiguous about load? The DC Circuit Court said that they were not ambiguous. They strenuously disagreed with the court in American Farm Bureau. How do you reconcile those two cases?
Well, Your Honor, I apologize, Your Honor.
No,
While I'm unfamiliar with the DC Circuit Court case, I do understand that in American Farm Bureau, when they were looking at the term in its entirety and whether or not that it was allowed an annual loading, they did find it to be ambiguous because total maximum daily load is a term of art. It's supposed to be taken as together as a group. So when you're looking at the term total maximum daily load, the individual words should not be parsed out, and the term should be construed in the broader context of the Clean Water Act. And as we've seen here, at least with the EPA's decision to implement an annual and phased load, it furthers the goals of achieving clean water while also considering the cooperative federalism. We have to delicately balance these two factors. And nevertheless, still, despite, yes, Your Honor.
Okay. Yeah, and balancing those delicate factors on the reasonableness assurances issue, if we could turn to that for a moment, curious as to what you think about this. First of all, what standard of review does EPA argue applies in our evaluation of EPA providing credit for implementation of BMPs when there's a reasonable assurance that they'll be implemented? What's the standard review we're supposed to apply to that in EPA's view, and why?
To answer your question, Your Honor, the standard review is up to the agency discretion of whether or not they want to follow their guidance documents, which establish the reasonable assurance standard. And this is because an agency cannot be found arbitrary and capricious for not complying with a guidance document, or rather, just as Your Honor explored with counsel for Chesapeake Lake Watch, the arbitrary and capricious and abuse of discretion standards of review only apply where an agency decision fails to comply with its own regulations. So, for example, in the Illinois Northern District Court's 2007 National Banking Mitigation Association versus the United States Army Corps of Engineers opinion, the court found that applying the arbitrary and capricious standard of review where the Army Corps of Engineers violated its own guidance documents would be improper because guidance documents are not binding regulations. And this same approach was adopted by the Western District Court of Missouri's 2021 Missouri Coalition for the Environment Foundation versus Wheeler opinion regarding a similar challenge raised against a different EPA Clean Water Act guidance document.
Let me interrupt for a second. So how much deference should we give EPA in its use of BMPs as providing credit in the TMDL analysis? Is what I'm asking.
Ultimately, Your Honor, the EPA should be afforded Chevron level deference when it comes to whether or not they decide to adhere to their guidance documents. However, I understand there was a lot of conversation about State Farm, and I'd like to clarify a little bit about that with respect to how it applies to this instant manner. But ultimately,
before you move to State Farm, I just want to make sure I understand. So you said that prior that guidance documents and cited some precedents are not subject to Chevron deference because they were not done through rulemaking, but you would like us here to give your guidance document on reasonable assurances Chevron deference.
Your Honor, respectfully, the EPA's position is that the guidance documents, not themselves, are entitled to Chevron deference. And in fact, we are not bound to the guidance documents, and we do not have to adhere to those guidance documents because they are simply that, guidance documents. However, the EPA's decision to adhere to their own internal guidance document is ultimately up to the EPA because it does not create any legally flowing consequences. And this was the exact same conclusion that we discussed with the National Mitigation Banking Association versus United States Army Corps of Engineers opinion. And
Counsel,
also,
are you saying there's no bounds on EPA's decision-making under the APA?
Absolutely not, Your Honor. The APA still has the ability to regulate the EPA with respect to how it implements the Clean Water Act. However, Your Honor, I see my time is
a little, I'm sorry, I wasn't clear. My question was a little different. It sounded to me like you were saying EPA has unfettered discretion on how it decides matters, that it can just ignore its own guidance or other matters without expressing a reason for doing so. And that doesn't, how does that comport with the APA, the Administrative Procedure Act?
Your Honor, my time has expired. May I briefly answer your question?
Yes, you may.
Thank you. Under the APA, the EPA can only be held, the EPA is only subject to review under the Administrative Procedure Act when it violates its own regulations or legally binding decisions. However, here, a guidance document is not a regulation and it's not a legally binding document. So ultimately, it's not subject to review under the Administrative Procedure Act. Thank you.
Thank you, Counsel.
Thanks.
Thank you.
Give us a moment, Counsel, before we move to rebuttal. And please remind me how much time you've reserved for rebuttal before you begin.
Yes, Your Honor. CLW has 2 minutes for rebuttal.
Thank you. The panel is ready? Okay, please proceed. Thank you.
Your Honors, CLW has 2 points on rebuttal. First, issuing a TMDL which mathematically necessitated effective BMPs, but not requiring reasonable assurances, was arbitrary and capricious. Now, CLW fully acknowledges that agencies have flexibility and they are not bound by what they say in guidance documents as if they were rules. However, under State Farm, EPA was required to articulate a reason for departing from their own decades of precedent, and they failed to do so. EPA allowed New Union to cash a check that they knew was going to bounce. That fails the second of 4 categories that Justice White identified in State Farm as arbitrary and capricious. Now, second, CLW also recognizes the awkwardness of asking you to hold one word, total, ambiguous, while maintaining that daily is unambiguous. But it's not what these individual words mean read in isolation. What matters is whether or not Congress spoke to the precise questions at issue within the context of this term of art. And with total, Your Honors, ironically, you might say that the ambiguity is clear, because under the canon of surplusage, total must mean something other than maximum daily load. And that's why it allows for both waste load and load allocations. Now, for all the reasons that we brought before you today, this is a case about protecting a body of water in our community. We ask that you find for CLW on all 4 issues. Thank you.
Counsel Nicholson, just give us 1 moment. And if you can remind me how much time you've reserved for rebuttal.
I've reserved 1 minute for rebuttal, Your Honor.
Thank you.
I have 1 point on rebuttal, Your Honors. As Judge Dunn correctly stated to counsel for EPA, EPA's interpretation of total raises cooperative federalism concerns. Counsel for EPA and CLW attempt to dismiss these concerns without any legal substance. This court should reject EPA's interpretation under the rule of clear statements. As the Supreme Court has repeatedly emphasized, such as in Solid Waste Agency of Northern Cook County versus US Army Corps of Engineers, prioritizing one land use over another is an essential function of the state. And where an agency interpretation disrupts this function, the court must require a clear statement. Here, EPA's interpretation does disrupt this function. Under EPA's assertion, it can control all non-point sources in the Mississippi River Basin, which is about 40% of the continental United States. Therefore, without a clear statement from Congress that they intended to infringe so blatantly on state authority, EPA's interpretation must be rejected. Thank you.
Thank you, Council. Council Beams, just give us one moment. And if you could remind the panel how much time you've reserved for rebuttal, please.
Yes, the EPA has reserved 1 minute for rebuttal.
Please proceed, thank you.
Yeah. Chief Judge, your honors, may it please the court, EPA has 2 points on rebuttal. Counsel for Chesapeake Plain Lake Watch claims the EPA has cashed a check it knew would bounce. However, the state's credit history is backed by specific BMPs that will be implemented through the EPA's 5-year plan. Second, the court, as Judge May stated in questioning counsel for Chesapeake Plain Lake Watch, needs to give the executive branch the opportunity to get things right. The EPA is the overseer of the operation of the Clean Water Act, and as co-pilot, helped the state come back into the appropriate path with rejecting the state's TMDL for failing to account for the non-point sources, and thus will help improve the waters of Lake Chesapeake Plain. The EPA's approach here, as Judge Lynch mentioned, is more effective and only furthers that primary goal of the Clean Water Act in Section 101A, to restore and maintain the integrity of the nation's waters, especially the impaired Lake Chesapeake Plain. Thank you.
Thank you.
The Honorable Court is now adjourned. At this time, the judges will retire to deliberate. Our judges will return in 20 minutes.
At this point in time, I will turn it over to the judges to provide some feedback to the teams. We ask that all the team members turn on their cameras. After the judges provide their feedback, then presiding Judge Dunn will announce who the winning team is, and then at that point, the teams can identify who you are. I will now turn it over to presiding Judge Dunn.
Thank you, Kristen, and welcome back, competitors. What an incredible job you all did. I'm glad to see you all looking so calm and smiling. You really have to just feel good about how you presented today. It was impressive to me and Judge Lynch and Judge May. I'm going to give some general feedback really across the teams. We saw such an exceptional command of case law, and whether virtually we can't tell if you're using notes, but by eye movement, it did not look like any of you were using notes. Regardless of how you demonstrated that mastery, there was seamless ability to pull case law, to answer our questions about specific cases to even answer questions about cases that you might not have been familiar with, but to pivot really gracefully to something that you were familiar with. So that type of presentation in oral argument is really what will take you far in courts and before different administrative bodies. In terms of a few other things that we really, in our deliberations, commented on was a very nice, elegant use of asking for clarification from the judges. A few of you did need to sort of ask for a repeat of a question or a clarification, or Your Honor, let me just make sure I understand what you're asking about. And we agreed offline that sometimes we weren't very clear. And that happens, right? Because all of our minds are turning quickly and we're processing your arguments and thinking at the same time. And so sometimes the questions come out awkwardly. And so asking for that clarification, while sometimes it might take you down a little bit of a rabbit hole, you all managed it really nicely. And it's certainly something that you should never be afraid to do in front of a panel. Also, I might have been gently corrected even by citing the wrong part of the statute at one point, and one of the oralists said, well, that's actually 303E, not D. And also you can do that very, very professionally if it's relevant to the outcome. And so there were several examples throughout the arguments that really held that nicely. In terms of some specifics, because everyone wants to know a little bit about their specifics of their team, CLW, Chesapeake Plain Lake Watch, really great job on State Farm, and also some really nice use of the congressional purpose of the statute that was really interesting. So very clear argument. For New Union, really great knowledge of the facts, a nice use of the American Farm Bureau Federation case, the Third Circuit case. We were impressed with the use of the canon against surplusage, a great canon, and it was very well used. And also some really quick verbal footwork, responding to questions about the Clapper case and imminence. So really nicely done there. Also, both oralists for New Union used a lot of case law in your responses and did that in a very elegant way. For the US EPA team, really, you had a challenging argument to make about the informational tool that sort of kind of stands out a little bit, but did it very, very well, and held your ground. The oralists both made very clear prayers for relief, what you were looking for. That's a nice strategy for all the teams to be very clear. We are asking the court to do this and that. And it was very clearly presented who was arguing what issue. Although I think most of the teams, we didn't respect any guardrails that you put up about who was arguing what issue. We kind of blurred those lines a bit. And at the final round of a moot like this, being able to address the issue that your co-counsel was going to address, none of you did what we might see in earlier rounds, which is to say, oh, my co-counsel will get to that next, right? You all were very deft at going back and forth and answering whatever came up. And the final thing that I will say, I really liked from EPA team, and actually from all of you in the rebuttals, really nice integration of comments that the judges had made, right? So you said, oh, as Judge Lynch said, and as Judge May said, and as Judge Dunn said, you all did that. And that showed that you were really listening to the arguments and most of you came back with, well, as you asked, the State of New Union, and you wove that in, which showed that you were adapting your argument in real time. And that's what you have to do for oral arguments. So we saw a lot of exceptional advocacy from the six of you. And that is what a lot of what we talked about on our call. I'm going to pause and ask Judge Lynch and Judge May if they have anything to add that I may have left out.
I'll jump in and just say it was an incredible experience and you are all really amazing. Specifically for Chess Queen Late Watch team, I thought you did a really nice job of touching on the policy implications and what kind of is at stake here, without crossing the line and just making policy arguments, and certainly in a way that, you didn't undermine the legal strength of your case. And that's important for judges. We want to know the context. Most judges do. So I thought you really hit that really well. And then for the New Union team, I really felt like you were listening. I really felt like we were having a conversation. And I know on my court, that's how we view oral arguments. We're asking questions for a lot of reasons. We want clarification. We want to probe the strength and weaknesses. We haven't made up our minds. And sometimes the panel judges don't agree with each other. So we're pushing and pressing. So you shouldn't be afraid of oral argument. Look at it as a conversation. And like I said, I really felt like I was having that. And then, for Team EPA, I thought you did a great job as well, listening to what the questions were, pivoting, not just sticking to your script. That's something that's an easy trap, but you, I thought, avoided that very well and got your points across. So thank you very much. I learned a lot today.
Thank you and good afternoon. Can you hear me, by the way? Okay. So that was fantastic. It was such an honor to be in your presence, listening to your arguments, and to have, to use Judge Lynch's word, conversations with you about these topics. So I really enjoyed it. So let me just congratulate you. I've been there. So I was in this competition a very long time ago. So I have a sense as to what you've been through, all the energy and effort that you put into it, and all of that. So congratulations, hats off. It could change your life. It did mine. So as far as your arguments go, I just thought, again, I was just captivated by them. And as Judge Dunn mentioned earlier, our minds are whirring too about, we're trying to ask good questions to sort of interrogate what you know and to animate your arguments and so on. And so it really helps to be able just to have a conversation, which is really what oral argument is all about. It's reaching that kind of Zen stage of it, and you all did a great job. As far as the arguments themselves, some of the particularly strong aspects of all the teams was thematic. You each had a theme going in. I didn't remember. I couldn't write them all down. What it was like, to save the lake because it's dying or something like that. Is to deploy some kind of theme when you start off. I think that's effective. Secondly, I think each of you, all of your teams were effective on laying out your arguments. And we didn't let you get away with that because in this final round, we're anxious to get to the things that are on your mind and our mind and have this conversation. But you were making it clear as to what you were coming from, and then summarizing your arguments each time around. I also thought that the use of case law and the record and so on was terrific, and I thought the rebuttals were terrific as well. So congratulations to all of you, and congratulations to to the National Environmental Law Moot Court competition for doing this again this year. You know, the fantastic problem, Professor Copeland, and everyone who was involved in this, just making it, you know, it's still, in my estimation, one of the top moot court programs in the world. All right, thank you.
Wonderful, thank you so much. And I too competed in this competition
wow.
in 1994 and was eliminated at the end of the first round. So I still remember the hours with my teammates preparing, and how nervous we were to make the trip to New York, and, you know, just the whole stress of it. So you guys have done just a super job getting to this place, and all of you will have the honor of being finalists, but one team will be able to declare itself having won the National Environmental Law Moot Court competition. I believe it's almost the magic year. It's the 34th annual. So at this point, we are able to say the team that is the winning team is Team 29. Congratulations.
Congratulations.
Your mics are all off, so we can't hear you gasping, clapping.
Faces.
Thank you so much.
Congratulations, Team 29. Kristen is going to come back and give us a little bit more instruction. So Kristen, welcome back.
Thank you. Now we will have the teams identify who they are for the judges and for the viewers. First, Team 46, can you please tell us which university you represent?
We go to Duke University.
And Team 29?
Lewis and Clark Law School.
And finally, Team 8.
We are Stetson.
Thank you. Congratulations to all of the teams. You all put in a lot of hard work and it showed. And congratulations to our winning team, Team 29, who will receive the prized Storm King painting, which is awarded each year to the NELMEC winner. Professor Nicholas Robinson, University Professor on the Environment, and Gilbert and Sarah Curlin, Distinguished Professor of Environmental Law, Emeritus, will now present the special history of the Storm King painting.
The painting you see on your screen is Storm King Mountain at Dawn. It was commissioned by Professor Jeffrey Miller and I 35 years ago. This original painting has always hung in the hallways of the law school that wins the competition, and Lewis and Clark has had it several times. One of the things that we do is send a print of this original watercolor painting to the school after they have to retire the award. So you will always have a copy of this painting. John Halsey is one of the great American watercolor painters. He's in Kansas now, but he came to New York to follow in the footsteps of the Hudson River School of Painters. He painted for over a year in the Hudson Highlands, where Storm King Mountain is located. And he did it at night, in daytime, early morning, afternoon, all seasons. He chose the sunrise at Storm King, I think, because it's a moment of hope when the sun is just coming up over the mountains on the other side and hitting the top of the mountain. In 1965, this mountain was saved by a lawsuit that the Scenic Hudson Preservation Conference, a group of citizens not unlike our citizen plaintiff here, brought to stop the Federal Power Commission from putting a pump storage hydroelectric set of pipes and turbines over the mountain. It opened the door to what became citizen suit, the authority in Section 505 of the Clean Water Act to bring suits. It permitted beauty and the aesthetics to be part of an impact. So the adverse impact on beauty was a part of the holding in which the court remanded back to the Federal Power Commission the decision regarding this mountain to take into account all of its environmental impacts. It ultimately found that the striped bass in the river would be adversely affected, as well as the beauty of the place. John Halsey is in Kansas now. You can look him up with his wife, Ann Trusty, on the web. He does oil paintings too. He's an extraordinary painter. His works, including this prints of this painting, are in the Hudson River Museum with their art collection of the Hudson, and in a number of museums around the nation. So it's with great pleasure that the faculty every year and the Moot Court Board are able to present the original of this painting to keep the spirit of Storm King alive, and the hope that we will be able to overcome the environmental degradation trends that afflict us still today. With the brilliance of the competition this year at all levels, I must say, we are now ready to take that battle on with another generation of environmental lawyers. So I congratulate all of the participants in this year's competition. Thank you very much.
Thank you, Professor Robinson, for that wonderful step back in time to one of the competition's oldest traditions. And also my heartiest congratulations to all the finalists and also the winner. So this brings us to the end of the 34th annual Jeffrey G. Miller National Environmental Law Moot Court Competition. Again, thank you all to the judges, the teams, the students, the faculty, and the staff who really made this year's event possible. And as a reminder, today's event was recorded, and so it will be uploaded to the law school website for future viewing. And finally, we encourage you to visit our Twitter page and share your comments after the event. Thank you to all, and enjoy the rest of your day.
Thank you.
Thank you.
Thank you.